Um, Welcome to the event. So, Mr. Kishore Mandyam will be giving the welcome speech. So, I invite Kishore to give us a welcome speech.
Thank you. Thanks, Arnav. Um, as a non-lawyer, man on the street, the Constitution worries me, right? It worries me when I see grieving parents put in jail for 9 years. It worries me when I see a driver beaten into submission and admitting a crime that he didn't commit. But then I also think that this 90,000 word document put our second longest serving prime minister into jail for a crime she did commit, right? And among our neighbors, it's probably the single biggest contributor to keeping us from sliding into a den of tribal rivalries, because we have enough tribes in this country. Right? But at Daksh, we looked at the Constitution and we said, there is a much more immediate value to it. We need a platform where we can actually get together and reflect on issues that are more current, more relevant. We've done this for 6 years now. This is the 6th year. And this year, we have a doozy. We have an issue that is affecting every one of us. Again, as a technician, as a technologist, I look at privacy and I say, what's the big deal? I roll out some software, firewalls, hardware, make sure credit card numbers are not stolen, and we are done. But then I get that SMS from Airtel, which says I have to put my Adhaar number next to my telecom number. And I'm saying, really? This worries me. But I have no knowledge about these things. And I'm hoping that today, with Mr. Arvind Datar talking to us about privacy in the digital age, I will learn something, and I'm looking forward to a lot of conversation. We also have the release of our 2017 Access to Justice report, which last year did very well. We got very good feedback from people who read it, who put it together and contributed to it, and so on. And this year we're hoping it'll be even bigger. So without much ado, Harish, over to you for the release. And welcome everybody. Studio? The books?
Thanks, Kishore. So, we're very privileged today to have in our midst one of the senior most practitioners in the city of Bangalore and a legend in his own right, Mr. B.V. Acharya. So we think it's fitting that we request him to kindly release our report. Mr. Acharya, please. And sorry to spring it on you at the last moment. Mr. Datar. Sir, please, sir. Sorry. I'll take 5 minutes to explain, to briefly tell you what this report contains and how different it is, partly from the, I'm sorry, okay. How different this report is from last year's report. As those of you who have been following our work know that last year we released what was called the State of the Judiciary report, essentially documenting data around how the judiciary functions. So for the lawyers amongst us, the focus was not on substantive justice, but the process, because we all know that judicial delay is a fact of life in the country. And as Kishore referred to it in his brief introduction, it's something that has overtaken our judicial system and is actually threatening even the qualities of substantive justice that we stand for. For example, a fair hearing. How fair can you call a hearing if you're only being given half a minute or sometimes half a second to either say something or it will get postponed to another date. So when we started working on what we call the Rule of Law project, the idea was to collect data so that we can understand what this judicial delays problem is all about, and to analyze it in a manner that becomes helpful for policymakers to suggest proper changes. So last year's report was very well received. We sent a copy to every High Court judge in the country and the Supreme Court judges. Because of that, a lot of new experiments are being carried out in a few states, some of which are still in the works, some of which will be announced probably shortly by the High Courts themselves, where they're trying to see what can be done to improve day-to-day efficiency of the subordinate courts. Because I think for us to go and suggest something in the High Courts, I think we still have a long way to go. But subordinate courts, we have made some move forward. Last year, we had also conducted a survey amongst litigants in about 300 district courts across the country to understand the common man's view of the courts. This year, the report is not titled State of the Judiciary, but it's instead titled Approaches to Justice in India, partly because we did a major survey, and the first part of the report on the survey is contained in this book, covering about 46,000 households across the country. The idea was to check how many people access courts in this country, and if not everybody is accessing courts in this country, what happens to the problems? And one of the main findings of our survey is less than 5% of the total population actually come to courts. And if that is not astonishing enough from a rule of law perspective, where do the other 95% go is the more important question. And our survey answers some of that. And it's a very interesting read. We have just analyzed the major findings and included in the report. So I would urge you all to take a look at it. In the coming months, we are planning to release more and more details of this, the report. This year's report contains about 4 sections. The first one is about the survey and the search for justice. So what is the search for justice? What does justice mean? There's a very provocative article by a non-lawyer, Ashwin Mahesh is not here today because he's traveling, about what is the sense of justice in this day and age in our country. Then we have the findings of our survey, which we call the paths to justice. There's another very provocative article by the Swamiji of the Chitradurga Pita, who conducts every Monday what he calls an informal mediation session. And courts have actually recognized his proceedings as an arbitration proceeding. And unlike other alternate means of justice where no principles are followed, or religious principles which are not in consonance with the Constitution are followed, this proceeding is something to be believed. And he is doing it without a break, I think for the last, Aruna knows this detail, for the last how many years? 10, 15 years. And we have got a recording of that, which we hope to release at some point of time. There's also an interesting article on Gandhi's juris conscience by the former Vice Chancellor of the Gujarat Vidyapith, Mr. Sudarshan Iyengar. In section 2, we have more details on the delay facing the high courts and the subordinate courts, and we've also included what we call is the top 10 measures that we need to take for maximizing judicial time and improving justice. In section 3, we look at some of the specific case types. For example, we all talk about, all the newspapers carry details on check bounce cases and how long it takes. So we have analyzed some data as to what are the problems, where do they get stuck, and all of that. There are also studies on tax litigation and how government reacts to tax litigation, a case study of a tribunal in Karnataka, and also an article by an American scholar called Leah Rose Goodwin, who talks about how courts in California manage and administer their judicial system. and the case flow there. In the last section, we have views of a judge, a sitting judge of the Madras High Court, Justice P.N. Prakash, who talks about the kinds of cases that come before him. We have a prosecutor again from Tamil Nadu, Judy Angelo, talking about a prosecutor's views. We have Mr. R. Srikumar, the former DGP and IG, talking about the challenges of criminal investigation and how trusting the police is important for the criminal justice system. And we have an interesting empirical paper on the judicial tenure of judges in the Supreme Court, the only paper in this book that focuses on the Supreme Court. And we have a couple of economists who have written on how judicial budgets are made. So I won't go any more into the details. I would urge all of you to read it. Again, this time we are planning to send this to all the sitting High Court judges, the Supreme Court judges, and other prominent policymakers, including lawyers. So today, because the book came to our hands only a few hours ago, so we have about 100 copies outside. I would urge all of you to buy it if possible, because it will at least cover our courier charges when we send it to all the High Court judges. Okay. Thank you very much. That's all about the report. Now, I request Mr. Arvind Datar to deliver the Constitution Day lecture. Incidentally, Mr. Datar was also present at the release of our first report last year in Delhi, so I think hopefully his presence will make sure that this report also faces the same amount of success. If you want to sit, you can sit. Or
You can hear me, right? Yeah. So I'll just keep the mic slightly this way. So this is Jugaad. Can you hear me at the back? Yes. I must thank Daksh for inviting me to deliver the Constitution Day lecture. I think 26th November is our law day, and they asked me to speak at this year's function. In a not very happy state of affairs, the judgment of the 9 judges on right to privacy was perhaps a really welcome silver lining to the judicial cloud. Now, I decided to speak on this because it is extremely topical, and we expected the Adhaar case to start on Tuesday, but I don't know whether the Delhi matter is going to go on, but then we're going to start the Adhaar case immediately. I think you mentioned that you don't know why your bank account has to be linked with Adhaar. Even I don't know. For the life of me, I was asked to be a director of an NGO, and they said you must have your Adhaar number. So I'll come to that part later. But this whole debate on the right to privacy started on the 11th of August of 2015. By that time, Adhaar was being implemented by executive instructions. And the Supreme Court said that, look, you can't have Adhaar for not more than 6 items. That is your ration card, gas connection, 3, 4, 5 items were there mentioned by the Supreme Court. As the hearing was to start, the Attorney General made a statement that there is no fundamental right to privacy in India. The moment he said it, the judges told him, on what basis are you saying it? And he referred to 2 judgments, one of 1954, which was rendered by 8 judges, and one in 1962, rendered by 6 judges. It's odd that they were of even numbers, but that's how the strength was. Now, so once this statement was made by the Attorney General, the senior most, the law officer of the country, the judges said, okay, we'll refer it now to the Chief Justice to constitute an appropriate bench and decide whether at all there is a fundamental right to privacy. Frankly, as a lawyer, I thought this was a clear delaying tactic, because by the time the Constitution bench decided whether we have a right to privacy, it was the 23rd of August 2017. So 2 years passed, and from some 10 or 20 crore Aadhaar card holders, we came to 100 crore Aadhaar card holders. It is also astonishing that he said that there is no right to privacy, because if you check SEC, you will find that before the Adhaar judgment, there are 64 Supreme Court cases where they have used the word right to privacy. So there was really no debate. But why did it happen? I'll first deal with that, then I'll also discuss briefly the law of privacy, and then I'll go to the right to privacy in a digital age. You see, in 1954, just see how events turn and lead to momentous occasions. In 1954, the Dalmia company was raided. Those of you lawyers have heard Aram Krishna Dalmia. Right? The industry went to the dogs, but at least they had some contribution to develop the law. So I keep telling my friends from Calcutta, I said, if you don't have industry, at least you have developed the company law. So anyway, so in 1954, the Dalmia company was raided, and the Department of Company Affairs seized some records. He said, you can't seize those records because they violate my right of Article 20, right of, it will be a question of self-incrimination. 23 is a bar against the search, a simple point. Supreme Court obviously said that there is no question of your fundamental right being violated, you have violated the Companies Act, they have seized some record, what is the big thing about it? But in that 8 judges judgment, Justice Das makes an observation, passing, saying that unlike the 4th Amendment in the US Constitution, we do not have a right to privacy. So he said India doesn't have a fundamental right to privacy. That statement was there. Now, ironically, if you see the 4th Amendment to the Constitution, there is the word right to privacy is not used anywhere in the US Constitution, nor in the Indian Constitution. What the 4th Amendment says is, you know that the US Constitution came in 1776 and all the rights subsequently came in 1789. And the 4th Amendment says, briefly speaking, that your house cannot be searched. There's a bar against unlawful searches of a person's home, his physical space. And that really is based on Lord Coke's dictum that every man's home is his castle. So this was an observation saying that unlike the 4th Amendment, we don't have a fundamental right to privacy. End of the story. 1962 came that historic case of Khadak Singh, where what happened in the UP, in the state of Uttar Pradesh, the police could do 4 things. They could have surveillance over you, they could maintain your records, they could ask for your, ask you to come for inspection, and the last and the most dangerous was, they could make domiciliary visits were permitted. Now these domiciliary visits were done at night, and Mr. Khadak Singh was admittedly a person with a criminal record. He complained to the Supreme Court that, look here, the daroga, the police officer comes to my house at odd hours of the night and asks me where did I go, what did I do, who came to my house, and so on and so forth. And he said, this violates my right to privacy. Now in this subsequent Khadak Singh case, it's a judgment of 6 judges. There they say the UP police can ask for records, they can maintain records, they can ask you details, but they struck down the provision regarding domiciliary visits. They said visiting a person at odd hours is completely unconstitutional. So these are the 2 cases which then, and then after that there was nobody bothered about the right to privacy. Our Attorney General said that India doesn't have a fundamental right to privacy. Just a few historical background of the US Constitution which will tell you, the topic is right to privacy in a digital age. And you will find that this right to privacy is going to be from the, not only Stone Age, but the electric age, the information age, digital age, and I don't know what future age is going to be ahead of us, and how the right to privacy will be all pervasive. And look at the fascinating way in which the courts have developed the right to privacy. Now, as I said, the 4th Amendment really says you can't enter a person's home, cannot search it. So it's a case of not invading a person's physical privacy. In 1926, the first question came, Olmsted versus the United States, where that was the day of prohibition. You know that the US prohibition was a big thing. In fact, people say that was the start of the mafia and so on and so forth. Incidentally, Joseph Kennedy made his money in the prohibition days. But this was the date of prohibition. And this man's phone was being tapped by the FBI because he was a bootlegger. The question arose whether phone tapping amounts to violation of a right to privacy. And the US Supreme Court said, the right to privacy is only regarding your home. They have not invaded your home, they have not searched your home, they have tapped your conversation. So wiretapping is not a violation of a person's right to privacy because privacy means physical space, physical privacy alone. That was 1926. But those of you who are lawyers, please read the dissenting opinion of Brandeis. With remarkable foresight, he says, we are getting into an age where newer devices are being devised. We do not know where it will lead us. And what a man says in his closet can soon become known to the entire world. So what you say in your bathroom can be known to the world. He says in 1926. So, but Brandeis, in fact, Brandeis wrote the article in 1890 in the Harvard Law Review, where he said the most important right is the right to be left alone. Chandrachud has pointed out that it's not Brandeis first, but some other author has mentioned it earlier, but that's a different story. But the most important right to privacy is the right to be left alone. So Brandeis points out that, look, we are coming into an age of technological development. What you say in the bathroom can be known. So this is a very dangerous thing. I don't think that we should permit wiretapping, but it was a voice in the wilderness. And it's a very funny thing of the law that very often dissenting opinions become landmark judgments later. Right? Whether it is Fazal Ali's dissent in A.K. Gopalan, or it is the dissent of Khanna in JDM Jabalpur, all these become the law later. Now fast forward to 20 years, we come to Katz versus United States. Here what happened? After the war, gambling was a major vice. And Mr. Katz used to transmit the bets, etc., on the phone. So what they did was, they knew they were following Katz. Again, they were following Katz. So they used to know that he goes into a particular phone booth and makes calls. So they put a bug in that phone booth so that they could tap his conversation. So you'd go in, make a call and so on. Now the question was whether putting a bug and recording his conversation is a violation of right to privacy. What do you think? Now the Supreme Court said Olmsted is wrong. When you talk of privacy, it is not a person's physical space, it is his personal space. When he goes into the booth and closes the door, that is his private space. What he speaks, to whom he speaks, what he says is entirely a matter of privacy. You can't record it unless you have an authorized warrant. So Katz was a major decision where they departed from the physical space and went into the case that a man's privacy is not just invading my home and so on, even what you talk, etc., that is entitled for privacy. Then of course the matter goes on further, I won't go into details, but I'll tell you why I mentioned this, because when this Adhaar case was, the privacy case was being heard, Chief Justice Kher told us that we don't have much time because he was retiring in August. And he asked us to ration or divide the time amongst us. So I was given the task of covering the US law on the subject, and that's how I could make a more detailed study of that. We had studied very cursorily in the law college, but when we studied this, we found out that privacy which was mentioned in 1789, see how it develops. From a mere house, it goes to wiretapping, it goes to tapping of a phone, and then it goes into other areas of human conduct. The right to